is that most of the paying customers are law enforcement, and defense experts and defense investigators don't have the same money to throw at the problem, and this may bias the development of technologies in favor of identifying evidence of guilt rather than identifying evidence of innocence. So any support Congress could give to AI technologies designed to identify evidence of innocence would be very promising, and my biggest concern are technologies that are kept secret and withheld from adversarial review by the vendors.
And Mr. Aguilar, you might have mentioned this, but with your experience in law enforcement, have you had occasion to use any kind of AI technologies with ballistics information, with cartridges, spent bullets?
Absolutely, Senator. So with our partnership with ATF, we do have an in-house ballistics program, a Crime Gun Intelligence Center, and it's one of many tools that we employ to investigate and prevent violent crimes. It's certainly been helpful.
Is there an AI component, though? Because before there was AI, there were still computer programs that compared, for instance, the markings on an ejected cartridge or the markings on a spent bullet to other markings in the same way that fingerprint searches take place, not so much with modern AI as just computer databases.
So our definition of AI sometimes changes, right? As technology becomes more mainstream, we sometimes think of it as less AI than newer technologies. But if we look at ballistic evidence where it's compared through an automated system in a database and then later has to be verified by a human analyst, and it makes connections through the automated process that has to later be verified by a human analyst. So in that sense, I certainly consider it AI, as it has to be human verified.
Thanks very much, Chairman.
Thank you very much. I'm not sure who was here first. Padilla. The California is well represented today. Senator Padilla.
Thank you, Mr. Chair. Speaking of California, it was recently reported that a local police department in my state used AI to render a 3D image of a suspect from crime scene data DNA and then attempted to run that image through facial recognition software in an effort to identify a suspect. Now, this is the first reported case of law enforcement attempting to use facial recognition technology, which has questions in and of itself, on an AI-generated image. The incident first occurred actually in 2020. So it's been a couple of years, but the public did not become aware of it until it was reported this week. There appears to be a little transparency, questions and concerns about how AI tools are being used by police and prosecutors during criminal investigations, and I cited just one example. First question is for Dr. Howard. What steps should be taken to ensure that defendants and the public are aware of when AI is being used in criminal investigations?
Part of our policy option calling for transparency would envision a scenario where it is revealed when algorithms have been used in one form or another. And to speak to Mr. Aguilar's point, AI is often what we now think of as automated technologies was originally considered AI. What most people call AI now is machine learning, which is trained on training data. We believe that transparency step should be known. People should be aware when an algorithm has been used in one form or another as part of the evidence collection and assessment process. We do believe, however, it's very important to validate the results of those methods, and in this case, the articles that I've read have not indicated whether any validity testing has been conducted on the reconstruction process for the face, and then whether those faces can be reliably run through even the best algorithms. We've not seen any data indicating that those have been tested.
Exactly. So brings up a whole host of questions. Follow-up question for Professor Wexler. Welcome from California. How critical is transparency for fostering a positive relationship between citizens and law enforcement for ensuring just results in criminal proceedings?
Transparency is crucial for a positive relationship between citizens and law enforcement and just results in criminal proceedings. Transparency is one of the key functions of the adversary system. We have an adversary system to enable the criminally accused to scrutinize and contest the evidence against them so that we can ensure that law enforcement's use of that evidence is effective, accountable, and legitimate.
Now, a question on a separate topic. Last September, the GAO released a report showing that several federal law enforcement agencies, including the FBI and DEA, among others, did not require their agents to be trained on protecting civil liberties and rights when using facial recognition software. As I mentioned earlier, facial recognition software begs a whole host of questions in and of itself. But this lack of training is troubling given that the technology has been shown to produce biased results, particularly when it involves identifying black and brown persons. Back to Dr. Howard. Since the release of this publication, have steps been taken to ensure that federal agents are trained on how to responsibly use facial recognition technology?
We are not aware of any changes as a result of that report. That doesn't mean they haven't occurred. We just have not been able to follow up with the agency to see whether.
So then the bottom line question is, what recommendations do you have to this committee, to the Senate, to Congress to advance this?
One important feature of facial recognition is the need to test and verify the accuracy and the demographic bias. And this is one of the things that NIST does in its testing, but NIST does not exhaustively test every algorithm. It tests the algorithms that are submitted to it for testing. So one possibility would be to require algorithms to be tested through an independent third party such as NIST if they're going to be used for federal law enforcement purposes. That would add that measure of third party independent accountability. If you're using the best tools, can an error still occur? Of course, human beings make lots of errors as well. And many of the most highly publicized errors with forensic algorithm tools have actually been traced back to errors the human analyst made, for instance, submitting evidence that was not of high enough quality to the algorithm, and the algorithm's then unable to give a reliable result.
Right, and you have confidence that NIST or whichever federal entity ends up with this responsibility has the capacity for determining guidelines for testing and certification of algorithms?
We've not looked at that directly, but we do know that NIST is often tasked with the job of setting standards for such things and would seem to have
that's the flip side, right? You can do test all you want, but what are you testing for? And
right.
Determining what passes, what doesn't. Okay, thank you. Thank you, Mr. Chair.
I think when you get two parts California, one part Georgia, that is New Jersey. But so with that,
You have to bake at 350 for about 45 minutes.
Senator Ossoff, thank you very much. Please proceed.
Thank you for convening us, Mr. Chairman, and thank you to our witnesses for your expertise. Beginning with you, please, Professor Wexler. What technologies or practices are being developed or might need to be developed to make criminal investigations, law enforcement activity, civil litigation resilient against synthetic, fabricated evidence? There's much discussion about voice cloning and the rapid advance in that technology. You can imagine that being provided by a malicious third party to law enforcement to prompt a criminal investigation of a targeted individual, or other cases where such technology could be used to frame or improperly implicate somebody. How do you protect against that risk, and do you think it's right to think of that as a risk?
Oh, I think it's absolutely a legitimate concern, and it raises the question of whether our current legal system and current evidence rules are up to the task of maintaining accuracy and adversarial review with new technologies like deepfake technologies available. So when AI produced evidence or AI analyzed evidence comes into court, risks of error are present, just as they are with human witnesses. And yet, one of the new challenges is that some of the traditional safeguards we have for cross-examining human testimony don't apply to machine-generated outputs. So it's very difficult to put a AI output on the stand under oath and cross-examine them and observe their demeanor. That's not going to work. So the technology, I would say as a lawyer, that we need to develop to ensure proper safeguards is the legal technology of ensuring we have robust discovery and transparency rules available, perhaps more pretrial testing, access to these technologies for validation and scrutiny rather than simply relying on the current evidence rules as they exist.
Where AI is used for purposes of investigative analysis, transparency and discovery through the adversarial process could be sufficient. But what about verification? The verification of the veracity or authenticity of evidence that's presented in court?
So for evidence presented in court,
or let me say, or if it's presented as a predicate to open a criminal investigation prior to even arriving or perhaps never arriving in court.
excellent. So, right, as an evidence professor, I always have to tell my students the evidence rules don't even apply if you never get to court. So what are you going to do? And there I would say we really need independent researchers with no stake in the outcome to be able to have access to these technologies to test and scrutinize and validate them. And so one of the things that Congress could do here is require or incentivize through the federal grants program for law enforcement assistance that AI technologies used in the criminal legal system are open to peer review or scrutiny by independent researchers with no stake in the outcome. And that will help with that verification piece even before we get to trial.
And thinking about the rules of evidence and discovery, if synthetic and inauthentic evidence were used to open a criminal investigation, and the subsequent progress of the investigation yielded for criminal investigators sufficient evidence to prosecute, and the initial underlying inauthentic and synthetic evidence that was used to justify the progress of the investigation is never presented in court, would a criminal defendant ever have means of knowing that at the very beginning of the process that led them to this position was something artificial or synthetic?
Under current law, I don't believe there would be a requirement to disclose. There's not a clear path for that, and that's a concern. There's a process called parallel construction where law enforcement may undergo multiple investigations and present one path towards finding evidence in court and not disclose the other paths. So there may be an opportunity and a role here for Congress to mandate affirmative disclosures of investigative strategies.
And that's a concern as well, isn't it, where foreign intelligence information may be the root of a criminal investigation, but through parallel construction, sufficient evidence is developed by investigators and prosecutors such that the origins of the investigation being rooted in foreign intelligence is never disclosed to the court or to the defendant.
There certainly are concerns about that, yes.
Dr. Howard, any thoughts on verification of evidence? Think about deepfakes, voice cloning.
So we've done limited work on deepfakes. It was not a part of the work I'm testifying about today, but the fact that the current state technology is able to detect deepfakes, it sometimes takes time. It's not necessarily a quick process. And with deepfakes, that can be an issue if something is out in the public and causing harm and we can't identify it quickly enough. In the cases you're talking about, criminal investigations can take a long time. Prosecution can add time to that as well. So one would hope the technologies would allow us to identify synthetic evidence before it were brought to court, for example, in the case that Professor Wexler might be hypothetically talking about. But the tools in any kind of a fraud type scenario, the tools are almost always a step behind the fraudsters. They're creating some new way to do something, and those who are trying to detect it are just a step behind them.
So, or as Professor Wexler noted, the underlying synthetic evidence may never be brought into court, may never be scrutinized, may never be subject to verification. Dr. Howard, is your impression that the technology, have you done any study, do you have a sense of whether the technology for verification, for detection of synthetic evidence, such as voice cloning, is expected to stay ahead of the capacity for synthesis and production of deepfakes, or Are we expecting instead that the apparent authenticity of deepfakes will become so sophisticated, so advanced that it defies verification?
We don't have any direct evidence either way, but historically speaking, the detection tools are normally just a step behind the new creations of ways to perpetuate fraud. One might assume the same would occur here, but we have no evidence of that in either direction. We don't see any evidence at the current time of something being created that's totally undetectable. It just may take time.
Thank you. Thank you, Dr. Howard. Thank you all.
Thank you very much. Professor Wexler, I really do question whether Senator Cotton has seen WALL-E. But otherwise, I actually think he's a really intellectually rigorous and I don't always agree with his conclusions, but he is an intellectually honest person. And I think where he was going is really substantive, which is this idea of somehow the AI technology companies that we're talking about, that you rightfully asked for, adversarial scrutiny, peer reviews, and how urgent it is for us to get over this trade secret privilege. I guess the concern that I think that he was getting at was that those companies do have a legitimate, and again, it might be cynical to say that they're just interested in being able to continue to sell their product, but you had some good retort for the idea, and I want to scratch it a little bit more, that those companies get more protection by opening themselves up to that scrutiny. Could you just explain that to me a little bit more?
Sure, absolutely. So substantive trade secret law is a body of intellectual property that creates a negotiation between the public interest in accessing information and the goal of incentivizing innovation by providing property rights to the owner. And so there are limitations all the time to substantive property rights. Patent law has an expiration date, trade secret law has some limitations as well that are part of that policy balance. The limitation of trade secret law is that you only get a right against misappropriators, which is wrongful acquisition, use, or disclosure. And my position is that cross-examination in court is not misappropriation. So the only time the intellectual property interest would kick in is if somehow a protective order, if information is properly disclosed under the protective order subject to cross-examination for purposes of a criminal case, that limited case could be attorney's eyes only, expert eyes only. The only reason that a company might have a legitimate concern is if that protective order might leak. And what I was trying to explain, and I'm happy to have another opportunity to elaborate, thank you, is that in that unlikely event, and there's not evidence that this happens regularly, in the unlikely event that a trade secret were to leak when it was subject to a protective order, all of the substantive trade secret protections are still available to the intellectual property owner. They can sue for misappropriation, and yet there's even more safeguards than normally occur outside of court because you have criminal contempt of court charges.
Okay, so I understand that, and that's really, I think, a substantive point. And so to the extent you can, the only jeopardy, you don't see any real business pecuniary jeopardy to that person exposing their algorithms or their processes to peer review. You really can't think of any other business threat to them because clearly they're getting some additional safeguards. Is that what you're saying?
Correct. There's no legitimate business concern with disclosing.
Compared to Bolt, but go ahead.
Yes, thank you. I don't even know where the phrase comes from, but a brick is not a wall means relevance is a relatively low bar. It doesn't mean nothing, but it's not an onerous threshold like showing that this piece of evidence is going to prove your whole case. No, it just means you get information and you get to introduce it in court if it will make a fact at issue ever so slightly more or less probable. And then with all those individual pieces of information, all those little bricks that are each relevant on their own, you build a case.
Right. And finally, there's this big there's a great book, Why Innocent People Plead Guilty, because they face such an enormous stacking of criminal charges and the enormity of it all. And I guess we could imagine a situation where a prosecutor is sitting there saying, take this deal, we'll give you 5 years or else you're going to face 50 because we've got this evidence based upon AI, as a very intimidating moment for an overworked, as one of my colleagues was saying, defense attorney. Is that a concern of yours?
Absolutely a concern. I absolutely agree, and I'll just add to this concern that many indigent defense counsel may not have the resources to challenge the AI, but also individual defendants might the cost of fighting the case, even when they maintain their innocence, could be so great, risk of losing your job, risk of losing custody of your children, your home, that it is perfectly rational to plead guilty even when you haven't committed the crime.
All right. Chief Aguilar, it's interesting as an African American lives in an African American community that's highly impacted by crime, that you have these two dueling reactions. One is you see how unfair the criminal justice system is. I grew up in a predominantly white area, went to Stanford, Yale, saw lots of drug use, the enforcement of which was nil to nothing. But in communities of color that like mine, you see a tremendous amount of drug use. And then on the flip side, you see all these crimes, as you were eloquently putting, that are going on in your neighborhood that aren't being solved. So you have this almost double down discontent with your public safety, and that's a problem. There's one great criminal justice writer that says black communities have too much of the policing they don't want and not enough of the policing that they need, in terms of, as we said, the closeout rates of murders and shootings and the like. But your story is extraordinary. So I was so excited that you came as a witness today, because you're working so hard to restore that trust within communities, and that technology. And I saw this where the ACLU was dead set against me using camera technology and shot spotters. We invited them in to help us write the operating procedures. And then how much my community wanted this technology being used on their streets, because like, you don't live here, we want cameras on our streets and the like. So I guess this tension that I've lived my life is something you struggle with every day, and technology brings a whole new era of challenges to something that's so important for law enforcement, which is police community trust. And so I'm hoping with that context, could you sort of tell me what your hope is amidst this for restoring the kind of trust needed to safely, for communities to be safe? And then what is the excitement that you have as you see the future of this technology to even better help the most impacted communities have the kind of safety and security every community deserves?
So, Senator, to your point, absolutely. We know that, at least through my experience, in the communities that are the most affected by gun violence, I have never heard anyone in those communities say we need less of this. They want everything that we can throw at the problem so that their children stop dying. Right? That's the overriding concern in the communities that are most affected by gun violence. And so what I found is that these tools have helped us hone in on those people that are the drivers of repeat gun violence. We know through numerous studies that it's usually about 5% of our gun offenders that are driving 50% of the shootings. So AI has given us the opportunity, along with traditional policing methods, where we employ micro hotspot policing, where we focus on repeat offenders. We saw, for example, a disturbing trend in some domestic homicide cases where those incidents were preceded not by felony incidents of domestic violence, but by misdemeanors that perhaps we couldn't get to quick enough. And so we found a way to identify those people that were repeat offenders for domestic violence that were also carrying out other crimes, to where when we're talking about carrying out enforcement that's preventative in nature, we're not targeting entire communities so much as we're targeting those 5% of offenders and 5% of locations that drive 50% of our violent crime. So I think that numerous studies have also shown that the more police officers we have out there, the more resources, human resources, the more positive our impact on crime rates. But it goes beyond that, where we have to just also embrace a lot of these technologies that help us focus on the right people that are driving violence in our communities.
And technology is clearly a force multiplier. It allows one individual to do a lot more work, a lot more quickly. And you've been a homicide investigator, so you understand that, yes?
These technologies can cut out hours, even weeks worth of time in certain instances where we're talking video analytics, where we can get several weeks worth of footage and be able to compress it to those points that are most relevant and of evidentiary value. Absolutely.
And then how do you see, is there anything on the frontiers that gets you really excited about where you think policing might be with these tools in 5 years, 10 years from now?
I think that I think that a lot of the technologies, just like I mentioned earlier with ballistic evidence, to where we sometimes have a hard time considering that artificial intelligence. A lot of these technologies are going to become more mainstream. We use, with facial recognition as an example, we use it in our daily lives just to get into our phone several times a day. And so I think that these technologies hold a great deal of promise. I think that they become smarter and more accurate with time. We just have to put behind it the responsible policy, the right amount of research. The NIST facial recognition vendor testing, for example, is an excellent resource. If we were to consider, if Congress were to consider federal funding for some of these technologies, comparing it to sources that are available, like the NIST vendor testing, will be greatly helpful.
What about training and accountability of police officers? I mean, my police union resisted body cams, and then it shifted really quickly. They appreciated them because for citizen complaints, it was a very good video to have. My former director now thinks body cams is great for that. All that footage is great for training because you can break down officer interactions. I'm imagining that could be done with AI, looking at the volumes and hours, looking for certain patterns that might help to create more accountable policing. Have you used it all to hold your police to higher levels of accountability and transparency?
So, Senator, to your first point, there's never enough training, and so I am always a fan of more and better training. Right now, we are looking into a research partnership to where we will use artificial intelligence to go through those hours and weeks worth of body cam footage to not only highlight problematic behavior but also commendable behavior.